was not only outdated, but the documents they relied upon and the reports they relied upon were prepared for a completely different purpose.
The analysis or the figures that were attached to the LPC, it doesn't really play a role if we do not know that those were the figures that were used.
So there are two issues that arise. The first is figures in and of themselves say nothing, without an indication of why you thought those figures were important. The second is, I've given you the reference now, because some of the sources from which they obtained those figures go back a long time, firstly, were in the context of reports prepared for a completely different purpose. And so is of really no
So the
assistance.
figures that, or the statistics
Yeah.
that's attached to the answering affidavit of the LPC,
Yes.
are they not different or new? Are they the ones that were
And that's why I say we illustrate to you why they're just out of place. They're old, they were prepared in reports for a different purpose, and for that reason don't. But that was, first of all, so that's the figures that the LPC say. We say it was inappropriately sourced. In any event, there's no explanation of why it achieves the purposes. And then the final point, which I've made so often, that the minister doesn't show that he gave any consideration to that. Our sixth ground at page 19-166, I can sum up in a couple of sentences. I don't want to make a lot more of it. We say that there's an irrational specialized source code, and we make the point in paragraph 168 that the sector code is intended to apply to the sector. And in 169 we say that what this code seeks to do is place an obligation on state entities outside of the sector to do certain things in relation to what happens within the sector when they've got their own obligations elsewhere. Now that may come across as a technical point. It really isn't, because remember I indicated to you earlier that you've got the generic code and then you've got specialized codes, and if there's going to be a deviation, you've got to justify it. In this instance, you do run the risk, without that justification and with the deviation, that state entities, for example, could be utilizing services, say mergers and acquisitions, amongst accounting firms with one criteria in mind, but in relation to exactly the same services, if it comes from law firms, it will be another criteria in mind. So it is a bit of a problem, and we illustrate, we make that point in our ground six. That then takes me to the last of my grounds, and that's the grounds that I'm going to be dealing with, and that goes to the question of the strategy. Now you'll recall, and I need not re-emphasize it, we deal with it from page 19-169 of our heads of argument, but you'll recall that when I referred you to the Act, it required two things in section 9.2 of a strategy: one, the publication of the strategy, and the second, the use of the strategy. Now, in response to that, what is said by AFT is that there was a judgment in the SCA by Justice Nafsa saying that there was a strategy. Now, we've sourced that judgment. That's the judgment of the Oceania Group. It's set in their heads. And from what we've been able to read, let me be a bit cautious in stating this, but from what we've been able to read, that portion of the judgment tells you what the court à quo said. And if you ask me, am I certain about that, I've got to say to you no, because we've not been able to find the court à quo judgment. But it would appear to us that it comes under the heading, what the court à quo said. But you need not make that finding for a couple of reasons. The next is, if you read the case, you'll see that the existence or otherwise of a strategy did not feature in the issue the court was meant to determine or in its findings. So even to the extent that it said there was a strategy document, it was obiter. It didn't go to the issues there. The third point we want to make is it's a 2003 document. The Act came into effect in January 2004. The strategy document was meant to be published in terms of the Act. The fourth point we want to make is that in the very memorandum the minister says was relied upon, not by him, was relied upon. There's no mention of a strategy document. And the final point we want to make is the minister himself does not say he considered. He says that there was that if you want the strategy document, you can go and find it. It's published online. we make the point that at paragraph 182 that we think he's referring to something different. But it doesn't really matter, because whatever he might be referring to, he doesn't say, and that which you will find online, I actually considered. So we say it doesn't help one bit. Yeah, and I'm not going to again read out from the Act, because I went through the Act fairly carefully. It's a 9.2 point, so that's it. That then takes me to, you'll be glad to hear, to the last of my points, and then I'm going to hand over to an address I think I will enjoy listening to, because it's always so good. I'm going to talk about costs, and I'm not going to say much more than the following. First of all, this is a classic BioWatch principle case, and we set it out in our heads. We do say that if we succeed, we're entitled to costs. We did use 3 counsel. We think, from our perspective, we say with justification. That's always in your discretion. We think we're entitled to it, but it's your discretion. That's the first point. And I'm mindful of the fact that when you're going to make a cost order here, you're mindful of who is on the other side and what the issues are. So I don't have a difficulty with that. We ask for costs on scale C, but again, I'm going to leave that in your discretion. I'm very mindful of the type of litigation that we're involved in here. Justices, unless there are any further questions, those are our submissions.
No, thank you, not at this stage. Mr. Nkotobi?
Yes, thank you, Justices. Could I just hand up some documents that are extracted from the record that I will be relying upon?
Thank you.
So what your leaderships will find are 2 files. The first file will be, the smaller file will be authorities, the main authorities I will rely on. The bigger file will be the documents we've extracted from the record, but only those that will be referred to in the oral address. And then there is another document which is headed Comparison of Reasons in the Rule 53 record and Ex Post Facto Reasons. I think it's inserted somewhere on the side.
Oh, yes.
Yes, thank you. So those should be the most important ones. Mr. Baum has left some time in his address, I think about 35 minutes. I intend using it on his behalf. The Constitution imposes 3 principal constraints to the exercise of public power. The first is legality, which is the idea that a public functionary can only exercise those powers that are conferred to them by law. The second constraint is rationality, which means that the decisions taken by public functionaries must bear a rational connection to the evidence before them and must serve legitimate governmental aims. And the third constraint on public power is that decisions must not infringe the provisions of the Bill of Rights. This case is about all 3. The argument of the applicants is that the decision of the minister to gazette the code infringes the principle of legality that is enshrined in Section 1 sub C as a foundational value of the Constitution. They also submit that the gazetting of the code is irrational because it is not justified by the evidence that was before the minister at the time. And that will be the core of my argument. And I will take the court through the justifications given in the answering affidavit, and I will ask you to compare those with the record that informed the decision. And I will ask you to see that there is an obvious disconnect. But we will also make submissions about the Bill of Rights, particularly Section 9, subsection 2, because the defense, as we understand it, of the minister is that the code must be left alone because it advances the provisions of Section 9 of the Constitution. We will submit that in accordance with the insolvency practitioner's case, a mere claim of advancing equality does not insulate a decision from judicial scrutiny on the grounds of legality, also on the grounds of Section 9.2 itself. Section 9.2 is not a freestanding provision. It has specific requirements that must be met, and in this case, they have not been met. But as I say, I shall try to confine the bulk of my argument to why the publication of the code infringes the principle of legality and rationality. I must emphasize one point that Mr. Baum has already made, which is this is a review of the decision by the Minister of DTIC. That has profound implications to the judicial function to be performed by your ladyship. It means that you may take into account what the other respondents say, but only as explanation of what the minister decided. You may not substitute the minister's decisions for those of the other respondents. There is no challenge to any decision taken by the Legal Practice Council, and no challenge to any decision taken by the Minister of Justice. The sole challenge is to the decision taken by Minister Dow to publish the code. If I could then commence with the legality analysis. The codes, as Mr. Baum pointed out, are sanctioned by the provisions of Section 9 and 11 of the Broad-Based Black Economic Empowerment Act. Section 9.1 is important It provides for the power of the minister to publish the codes. In order to promote the purposes of the Act, the minister may, by notice in the Gazette, issue codes of good practice on black economic empowerment. The use of the word may introduces a discretion. That you can compare with Section 12 when it deals with transformation charters, which says the minister must publish in the Gazette a transformation charter which has been developed by the major stakeholders in that sector and advances the objectives of the Act. So what that means is that where the Act intends to confer a discretionary power, it uses language different to where the Act intends to confer mandatory power. The code falls into the category of discretionary power. Section 9.2 is also important in relation to the strategy, because it provides that a strategy issued by the minister in terms of Section 11 must be taken into account in preparing any code of good practice. We will submit, as Mr. Baum has done, that the facts illustrate that Minister Parkstow did not have any regard to any strategy when he published the code, the consequence of which is a direct infringement of Section 9.2. But it has a further consequence in relation to the failure to take into account relevant factors and therefore constituting a reviewable irregularity. Section 9.3 deals with the content of the codes of good practice, which allow the codes of good practice to specify targets consistent with the objectives of this Act and the period within which those targets must be achieved. The statutory basis for the strategy, as the court has heard, is under Section 11, subsection 1, which imposes an obligation on the minister to issue a strategy for BEE. And Section 11.2 deals with the contents of that strategy.
Well, Section 11, once again, is must.
Yes, it's must indeed. And in fact, Section 11.2 as well is must. Yes. So what we can see from that short analysis is that the legislature is conscious to distinguish discretionary powers from mandatory powers. And an infringement of the mandatory provisions results in invalidity. There are 3 codes that are relevant in this case that are issued under Section 9. The first code is the generic scorecard, and that appears at page 02. It's FA1 to the Norton Rose, well, to the Denise application. It appears at page 02-121 to 02-176. So that's the scorecard that applied until the publication on the 20th of September 2024 of the sector-specific scorecard. The second code that is relevant is Statement 003. That you will find at FA2 to the Denise application, and that appears at page 02/177. And the third code is attached as FA15 at page 02/691 of the Denise application. So I will be explaining then the case of the applicants by reference to those 3 instruments. I don't have time now to do an exposition of what the current code provides for. I can simply recommend to the court page 02/47, paragraph 80 to 92 of the founding affidavit in the Denise application, which contains the best exposition of the mechanics of the code that we are dealing with. So to understand then the relationship between these 3 codes, we need to look at Statement 003. That's what explains how these codes fit together. So that statement is at 02/179. It's FA2. Firstly, under paragraph 312 of that statement 003 at page 02/181, it states the proposed sector code must fully address all the elements in the generic scorecard. If you turn the page to 315 at 02/182, it says the proposed sector code may deviate from targets and weightings used in the codes only where those deviations are justifiable based on sound economic principles, sectoral characteristics, or empirical research. And under 3.3, the following page, 02/183, the code contains 3 grounds of refusal to issue a sector code. And item 4.4 states that any sector code is legally binding on the applicable sector, organs of state, or public and private entities. What that means is that the benchmark is the generic code. The specific sector may have its own code provided it complies with the requirements of statement 003, which affirms the generic code as the benchmark, but allows deviations on specified grounds. Actually, what I have said is not in dispute. If I can ask the court in due course, of course, to look at the minister's answering affidavit, he actually admits all of this, which is at 02/1256.
And we know we're only dealing with the minister insofar as
The DTIC minister, yes. I'm dealing with the decision maker.
yes.
So what I have said now in my exposition of the interrelationship between these 3 codes is common cause.
Well, it did seem to me that some of the other respondents do not agree, say he does not have any statutory power and so forth. But that is not an issue before us because the minister agrees.
Yes, precisely. Yes. If you can look at page 02/1255, paragraph 206.
Just a moment, 02.
Yeah, 1255. Paragraph 206, 207, and most importantly, when the minister directs his attention to statement 003, 208, and 209, and then ultimately he concludes at 213 that statement 003 was followed. He in fact even agrees about the grounds of refusal under 3.3 at 209. So the minister never takes issue about the binding effect, about the applicability, let me not say binding effect, but maybe a legal argument, about the applicability of statement 003 and the obligations that are imposed on him by that statement. What he argues is that he discharged those obligations. Now, whether he did or not is for your leaderships to decide. But what is important to clarify is that as between the applicants and the decision maker, there is no dispute about the relationship between these codes. So the consequence, therefore, is what I have stated before, that the generic codes are a benchmark. There can be deviation for sector-specific requirements. Those deviations are themselves constrained by statement 003. And so, therefore, in order to rationally pass a sector code, the minister must apply his mind to the provisions of the generic code. He must also apply his mind to the justifiability of deviation as required by Statement 003. And he must apply his mind to the evidence presented to him by the stakeholders. That then takes me to the first and overarching ground of review. Justice Passon, you have asked one of, I don't want to say the most important question, that may be unfair to the other justices, but you asked one of the most important questions, which was, what is the effect of a finding by the court that the minister did not apply his mind to the relevant considerations? The short answer to that is the judgment of the Constitutional Court in Simelane. It's the case of the Democratic Alliance versus the President of the Republic of South Africa, and particularly at paragraph 39. So that is the first judgment in our bundle. So if I could just read out, it says, this court in Sarfu said that the exercise of the president's constitutional power to appoint a commission of inquiry is not directly governed by the principle in the Johannesburg Stock Exchange case. It follows that this principle would not directly govern the president's power to appoint the national director either. This is not to say that ignoring relevant factors can have nothing to do with rationality. If in the circumstances of a case there is a failure to take into account relevant material, that failure would constitute part of the means to achieve the purpose for which the power was conferred. And if that failure had an impact on the rationality of the entire process, then the decision may be rendered irrational and invalid by the irrationality of the process as a whole. Therefore, there is therefore a three-stage inquiry to be made when a court is faced with an executive decision where certain factors were ignored. The first is whether the factors ignored are relevant. The second requires us to consider whether the failure to consider the material concerned is rationally related to the purpose for which the power was conferred. And the third, which carries only if the answer to the second stage is in the negative, is whether ignoring relevant facts is of a kind that colors the entire process with irrationality and thus renders the final decision irrational. So you have to consider in the first instance a twofold inquiry. One is whether these are relevant factors and whether or not there is a connection between the failure to consider those relevant factors and the decision. And if the answer to that is yes, then the decision is invalid. Now here, the job is a relatively straightforward one. The relevant factors that we are raising have not been invented by the law firms. They appear from the generic scorecard. They must be followed under Statement 003. The question is whether that's reflected in the legal sector code.
And they emanate from the very minister and the minister's predecessor.
Precisely. All of those three codes were passed by the minister. Yes. So, therefore, there can be no debate that they are relevant considerations because Statement 003 says they must be taken into account and then limits the extent of the deviations. So we can then go to the first ground of review, which is the failure to take into account relevant considerations. Now, this is not a subjective question. The minister, in other words, does not come to court and say, I was satisfied. Well, of course, he was satisfied. But the court itself does not simply ask, does the minister say he was satisfied? The minister asks an objective question, is there material before the minister that would justify the outcome that was reached by the minister?
And that justification must be explained.
And it must be explained, yes. Perhaps I should go there, my lady. to the explanation, we have two sources for the explanation. The first is the answering affidavit. Now, there is a limit to the extent to which an answering affidavit can be used to justify a decision. The answering affidavit may not invent a new reason that was not part of the decision at the time. Mr. Baum has made that point. But nevertheless, the answering affidavit is relevant in throwing light in the methodology of the reasoning of the minister. What does the minister tell us in his answering affidavit? So we're answering the first of the two inquiries. The first is, how does he explain himself? The second inquiry, how does that explanation stack up with the record? So if we look at the first explanation on the relevant considerations, I've listed here, I think, 15 paragraphs. And I will ask the court to have regard to the answering affidavit, starting at paragraph 126, about what he says happened.
Case line reference.
Sorry, my lady, it's 02-1236.
Thank you.
Yes. Now, paragraph 126 is crucial in relation to explaining the minister's understanding of his powers. He says, my role as the minister of the DTIC is to consider and publish the code after the sector has agreed on it. My role as the minister is to recognize and accept what the legal sector has collectively agreed on. Then, paragraph 206. That you will find at 02-1256. Sorry, no, I'm wrong. At 1255.
Sorry, can you just repeat that?
02-1255, paragraph 206.
It is, you're not wrong easily, so it's an exception.
Yes, I'm often wrong actually, most of the time. But yes, in this instance, I was way wrong. Yes, paragraph 206 and 207. So this is what he says at the last sentence of 206. As the minister of the DTIC, my legal responsibility is clearly spelled out in section 9.1 of the Act and has been carried out. And then look at how he explains that in the following paragraph. It is really not my space to be involved in the nitty-gritty of the LSC regarding the optimal targets in the LSC. This is a function of the legal profession and all the stakeholders. All the stakeholders had the opportunity to participate in the drafting of the LSC, and when it was published for comment, they commented. The comments were taken into account by the technical committee and the steering committee, and the final version of the LSC was issued, which I was duty-bound to gazette.
It seems that the previous minister had somewhat a different understanding of his role.
Yes. Yeah, indeed. There is that question, my lady, around what is the extent to which the current minister must slavishly follow the previous minister.
No, I just say in view of the concerns that were raised.
Yes, indeed.
And not duty-bound.
Not duty, yes.
But I need to have regard to because
yes.
I need, yes.
Yes, I think that, yes, thank you, my lady. It's clear that the previous minister diligently carried out his responsibilities. Then, my lady, the next paragraph that is relevant would be 238, which is at 02-1261. And this is where he admits the analysis of the scheme of the Act, of the code that I referred to from paragraphs 80 to 92. And then he says, I emphasize that the LSC is a product of the legal sector. We then turn the page to 02-1262, paragraph 240, where he says, I cannot comment on the specifics of the impact of the LSC on the applicant. I have executed my constitutional duties of publishing the LSC in the Gazette as requested by the legal sector. Now, I think it's probably sufficient to cite only those paragraphs because they illustrate the bigger picture that I'm trying to draw, which is what the minister always understood, that this is a function to be left to the legal sector itself. And if they presented him with a code, he had no option but to gazette it. And that is why later on he says, if you have a problem with the code, go to the Charter Council. Yes. And he expressly says that it is not up to him to consider the nitty-gritty or to read every scrap of paper, the nitty-gritty of the code, or to read every scrap of paper.
Isn't Toby, which section gives the reasons to refuse to publish? It is section 12.
Well, yes, the specific one is item 3.3 of the statement 003.
Isn't it in the Act itself as well? Not.
Yes, no, the Act simply gives, as I
Oh,
understand.
yes, you're quite correct. Yes.
It's section 9.1 says may. It's a discretionary power. Section 12, and that is where, in fact, your leadership is the question raises a different point, which probably should be made now, because I had it in my note. What seems to have happened is that the minister, certainly in his answering affidavit, has conflated the discretionary power in section 9, subsection 1, with the mandatory power in section 12. It's clear that under section 12, if the sector agrees on a charter, the minister has no discretion, he must publish it.
Yes.
Yes. But under section 9.1, the minister is not bound by what the sector does, because that's the exercise of his discretion.
Because one of the paragraphs you've read where the minister said he's duty bound.
Yes.
And then I recall, and you might be correct, it might be in statement 003,
Yes.
that there are instances where the minister may refuse.
Yes.
So it sort of seems to me to, there's a conflict.
Yes.
Because if you're duty bound,
Yes.
you cannot refuse.
How can you refuse? Yes. Yes. So under the statement 003, I mean, it's clear there that paragraph 3.3 contains grounds for refusal. And the minister's understanding of his powers seems to be a misconception, not of the law, but also of, not only of the law, but also of his powers. Oh, yes. Oh, yes. My colleague points out that your leadership is correct, that there is a section in the Act that prescribes the role of the minister in relation to a draft code produced by the sector. That is section 9, subsection 5, which says the minister must, before issuing, replacing, or amending a code of good practice in terms of subsection 1, publish a draft code of good practice or amendment in the Gazette for public comment, and grant interested persons a period of at least 60 days to comment on the draft code of good practice or amendment, as the case may be. So he tells them it's obligatory to invite comment, but it is his duty alone to gazette under section 9, subsection 1.
And he may refuse.
And he may refuse under statement 003, item 3.3. Yes. Yes. And your leadership have heard my arguments around section 12.
Yes.
That section 12 is about a charter where it's obligatory if the two requirements in that section are met. But section 9.1 is never obligatory. So we are therefore dealing with a fundamental misconception of the powers and the role. Now, there are some parts of the answering affidavit where the minister says, I applied my mind, I took into account everything, I was satisfied. Those you will find at paragraphs like 40,
Is the mere say-so good enough?
Yes, yes, that is exactly the point. So 40, 46, 47, 55, 108, 109, and 115. But what he does, I mean, what will strike the court in all of those paragraphs is the superficiality of the claims.
Because it's easy to say one thing, but there must not be proof, but at least some reason for the what one says. If you say, I duly applied my mind.
Exactly. So he must not say, he must show. Yes. Now, when you look at just the vast number of paragraphs and statements where he says, I understood my role to be to take what the sector has decided and to publish it. And then you take into account what actually happened. This is a minister who comes into office on the 3rd of July 2024. 3rd of July 2024. And he comes there in the context where there are these objections from the sector. He doesn't consult at all with the sector. By the 20th of September 2024, he has published.
2 months.
Yes. And this is a process that has gone on for years, and where his predecessor has pointed objections to the process. And then he just publishes. So it fits in with the scheme of his understanding of his responsibility. And what he says here is also crucial. When you look at paragraph 46, what he says he actually did in that period of the 2 months. So you will find this, yes, at 02/12/13. So what he says, well, what happened between the 3rd of July and the 20th of September when he published? What did he actually do? So you find that in his own answering affidavit, at paragraph 46 and 47, at 02/12/13, he says, as the new minister, I applied my mind to the matter after having been briefed by officials of the department who were ultimately involved with the LSC process. 47, Mr. Jacob Maputa, the Chief Director, BEE, signed a submission on 23 August 2024, which was supported by the Acting DGG Transformation and Competition Branch on 26 August 2024, and Ms. Malebo Mabije Thompson, Acting Director General, on the 30th of August 2024. Now, in the answering affidavit, we cannot find any other document that he refers to. And even the document he refers to, he never alleges that he read it. And he never alleges that he read the code either. And he never alleges that he read the objections from the law firms. Now, that document you will find in the bundle that we submitted at 205. So if you compare paragraph 47 of the minister's answering affidavit, and he speaks of a document that was prepared by Mr. Jacob Maputa, the only document we could find which has that date that correlates is the document at 205. In the case lines, it's 062627. Now, that document seems to be the only thing that the minister refers to. You will see at the end of it at 230, well, at 062654 or 232, it contains the signature of the minister. It refers to various annexures, and the minister in his affidavit never says he read those annexures. This is the only thing that we can see where the minister attaches his name to a document. The rest of it is the officials came to his office and they briefed him. Now, the question, therefore, and I'm just dealing at the moment with the
It's
question.
also, I do, I'm just reading recommendations. What is recommended? On page, what's it, 06, that's 200. It is recommended that the minister considers and approves the Gazette.
Yes,
The minister is hereby requested to sign.
yes, yes. Well, certainly the officials seem to have known what the minister should do because they asked him to consider the Gazette. Yes.
In any event, thank you.
Yes. Right now, I'm still on the question of the application of mind.
Yes.
Now, this has nothing to do with whether this is a good policy or a bad policy at all. It has everything to do with the constraints on the exercise of public power that are imposed by the Constitution. What my clients are entitled to is not the outcome, but it's the proper process. And they're entitled to insist that their elected representatives should apply their minds carefully to the objections that they put before him. The minister cannot say, I'm trying to do transformation, and therefore I'm entitled to override your objections. Now, what does this mean then? What it means is that you can find on the facts that there is no evidence about the proper consideration of the generic code. In fact, in the answering affidavit, nothing ever refers to it. That he read the generic code and therefore he knew what the landscape was. There is also no reference to the minister applying his mind to the circumstances of the deviation in the document itself, not later what he says in the answering affidavit. There is also no reference to the minister taking into account the submissions of the law firms. And then finally, there is no substantive engagement with the concerns that were raised by Minister Ibrahim Patel. Now, the court had asked what those concerns were. Those concerns, the court will find them. The answering affidavit starts at 06. The answering affidavit of Minister Patel starts at 06/1830. And the specific concerns are at paragraph 101, where you will find that at 06/1859, where he says, I only highlight the key instances of what the large 6 law firms identify as unjustifiable deviations, and then he sets them out in full.
Thank you.
And when you look at Minister Tau's affidavit, it's truly astonishing on this point, because even if he took the view that the applicant firms are trying to entrench the status quo, which is the kind of caricature of this case, even if he took that view, it's inexplicable why he dismissed the other minister's concerns. And he never actually engages with them at all in his answering affidavit. He just says, I read them, and that's it. Never engages with them at all.
Well, we know you read one submission document.
Yes, that's Mr. Maputa's document.
Yes.
Well, I would be
That's
careful
the only
there.
thing we know.
Yes,
We
yes.
don't know.
I would be careful there. He never plays that he read that document.
Oh,
Yeah. He says that it was signed and a submission was made. Never says he sat down and read it. And then he says they briefed him. And I'll ask my learned friend for the minister to show us where he says what documents he read. He never comments to any document, including the code that he published. Yes.
The minister does not deal and explain how his predecessors' concerns were addressed.
Exactly. He just says, I looked at them and I addressed them. I was looking for the part where it should be page 30. So that you will find at 02-12-27. So, and it's important, my lady, to just go through what he says and to see the extent to which he is so superficial in dealing with Minister Patel's concerns. In paragraph 100 of the answering affidavit, 02-12-27, he says, I was also briefed about my predecessor's comments on the LSE deviations. I was briefed that Minister Patel considered the LSE and the motivation for deviations, raised comments and concerns which were informed by 2 legal opinions. Minister Patel wrote a letter to the LSE Steering Committee and also had a meeting on 7 June 2024 to seek clarity on the following, and then identifies the questions. So you never find a section where he says, I read what the minister said. I do not agree with him for the following reasons. Yes. Now, that then takes us back to the test in the Democratic Alliance and the President case, which is whether or not you can be satisfied that this is a minister that applied his mind genuinely, meaningfully, as required by the Constitution to the material that was before him. We submit that it is clear that he did not apply his mind.
But he said himself that he's duty bound.
Yes, he said so several times.
And if one have regard to that submission, we do not know whether Minister read it.
Yes.
It simply said,
yes, precisely. Consider the code, yes. Now, what that would mean is that you would be entitled to strike down the minister's decision, which is paragraph 1 of the notice of motion. Or paragraph 2, because paragraph 1 is the intervention, paragraph 2 of the notice of motion, to strike it down purely on account of the fact that there were these relevant considerations. Some do not appear to have even come to his attention. Those that he claims came to his attention were dealt with in the most superficial of ways. And this is an important subject to my clients. It's an important subject to the sector as a whole. And so they are entitled to a proper consideration of the matter. If that has not happened, then we go back to the drawing board. He starts afresh. Next time when he publishes a new code, he must illustrate the evidence of how he substantively engaged with the provisions of the code and the objections raised by the law firms. That also means that the court itself does not have to deal with each individual item.
yes.
And that leaves it back to the people that should be working out what the targets would be, etc. But I do want to deal further with the individual items and to explain to the court why we say that the items that were ultimately arrived at were not justified by the facts that were before the minister at the time. And that is a sheer consequence of the superficial manner in which the minister approached the task. Let me start with the question of the existence of the strategy. What we know about the strategy is that it must be taken into account.
Mr. Mpari, just remind me, what did the minister say about the strategy? That it must be there in the first place.
Yes, in the affidavit I was dealing with, he doesn't specifically deal with the strategy. But I saw that
But one would think that it's something that the minister should deal with.
Yes. Okay. Well, in the heads of argument of Mr. Baum, this is referenced, which is at 19/169, at paragraph 180, 181, and 182. But I think what your leadership is asking me is to show precisely in the answering affidavit itself.
I just think it would be important because it's another mandatory
Yes, it is
requirement.
So 289, paragraph 289. Oh yes, thank you. I've now seen it. It's at 02/1272. Yes, so there are two paragraphs where he deals with this, at paragraph 288 and 289.
Yes.
So he says the contents of these paragraphs are denied. The strategy document is available to the public as it is published on the
yes.
DTIC website. Therefore, the strategy exists.
Yes.
That's not answering the point, because the obligation is to take it into account. He says the interpretation of section 11(1)(a) and 9(2) by the applicant is without any merit. Section 11 does not say that in the absence of the strategy, no codes of good practice may be issued. Section 9(2) says that a strategy issued by the minister in terms of section 11 must be taken into account in preparing any code of good practice. It does not say that if such a strategy does not exist, that a code of good practice may not be issued, and if issued, it would be reviewable. Paragraph 290, legal arguments will be submitted at the hearing of this matter. Yes. So that's the first affidavit. Now, he then filed, when my clients came to court, he filed a supplementary affidavit. When he dealt with this under ground 3, the court will find this at 022293. Paragraph 31. Then he says, as regards to ground 3, I have dealt with this ground in the Norton Rose answering affidavit, in that section 11 does not invalidate the LSC, and that section 11 strategy exists and is available to the public from the DTIC's website. So it's a repetition of the same point, that there is a strategy on the website, but he doesn't engage with the criticism, which is that you have breached your section 9(2) obligation because you've published a code without considering the strategy in circumstances where it is peremptory to consider the strategy.
Thank you.
So you have here another clear case ground of the invalidation of the minister's decision. And it operates at two levels. One, it's ultra-virus because the act
Yes.
specifies what the minister must do, and the minister has acted outside of the provisions of the act. And secondly, it's reviewable because it is a relevant consideration that is material to the decision that was not taken into account. And on the pleadings, it is common cause that it was not taken into account. And so we would submit, therefore, that just like the unexplained failure to take into account the justifiability of the deviations, which is ground 1, which incorporates Minister Patel's concerns, the same applies to the legality challenge based on the failure to take into account the provisions of the code, the provisions of the strategy. That then takes me to the third question, which is the targets. Now, this has generated a lot of heat in the argument, but actually it is straightforward. The government is entitled to set targets. It can set any targets. It can say 10% is too low, we want 20%. And that is not the argument here. And it is not up to the court to say we don't like target 1, we prefer target 2. But the government has no right to determine the legality of the targets. The legality is to be decided by judges. And when the judges determine the legality of the targets, they have to decide, firstly, whether the targets are consistent with the statute, and secondly, whether the targets have a rational foundation. Now, the problem here is that the targets simply do not have a rational foundation. Now, let me explain why. The documents we have, there are 3 documents that are crucial on this issue. Document 1 is a memorandum on deviations produced in August 2023. That you will find at 062498. And it deals with the ownership targets at 062504. So that's the August 2023 document. Now, I mentioned this document not because we concede that the minister considered it, because he never says he did. But what it provided for in its justification for the targets, 30% in year 1, 40% in year 3 and 4, and 50% in year 5. The justification it gave, and again I emphasize this, the government could have said 100% if it wanted to, provided it could produce a rational basis for it. If you go to the last portion there in the table where they explain why they got to those targets, they say these are higher than the targets in the generic codes, but warranted in view of the insufficient transformation since generic codes were first promulgated. Why? Continuing disadvantage experienced by black legal practitioners are demonstrated by research of the LSC, including relating to ownership patterns in racially mixed law firms. That still doesn't explain anything. It says, by way of example, LPC statistics for 2024 shows that on average, in the 6 largest firms, 25% of the directors are black. And then it says, this is where the explanation is. An increase of 5% over a period of 2 years is therefore reasonable. So remember this. An increase of 5% over a period of 2 years is therefore reasonable. So it's not my clients who came to that conclusion, it is the government. In 2024, they came back to this to update it in July 2024. On the 3rd of July, Minister Tau was in office. That update, the court will find at 063168. And they dealt with the targets at 063175, specifically of the ownership. If you turn the page to 063176, this is how they explained their targets. They say, by way of example, LPC statistics for 2024 shows that on average, in the 6 largest firms, 25% of the directors stroke partners are black. An increase of 5% over a period of 2 years is therefore reasonable. So that's the second time they say that. And then we go to the document which the minister refers to. And if we are generous, we say probably he means he read it. We then look at what explanation was given there and whether it changed from the 2 explanations given in 2023 and 2024. What we find there at page 062639, page 217, paragraph 562, 218562, and it starts at 217, 561, and then you turn the page to 562. He says the LPC statistics for 2024 show that on average, in the 6 largest firms, 25% of the directors stroke partners are black. An increase of 5% over a period of 2 years is therefore reasonable. Then you'll read 5.63, which is the paragraph that follows from 5.62. There you see an immediate disjuncture. It's no longer an increase of 5% over 2 years. It is an increase of 10% over 2 years. So which means on their own showing, they have imposed an unreasonable increase. Now,
So it was reasonable in 2 documents up until a certain time.
no, it's in all 3 documents.
It was
always
reasonable, 5%.
Yes, yes. Yes, we can just go back to this to just show the problem. So
But
we go back,
then it changed.
yes, to 217. It never changed, my lady. It was always the same. So 5.62, which is the minister's, the document prepared by Mr. Maputa.
Yes, maybe I understood you incorrectly. I follow you.
Yes, yes. So there he said it was 5% over 2 years. But the actual target was then made 10% over 2 years.
In the sector code.
Yes, in the sector code.
Now that was, yes. So up until the sector code was published, 5%
Yes,
was at all times considered to be reasonable.
precisely. Since 2023.
And now we do not know why between the last submission and when the...
Yes.
Why, okay.
We just don't know anything at all. Yes, about the departure. Now, it's a point that is taken by the firms. It's a point that is taken by the firms to say, but your own data shows that a reasonable increase is 5% spread over 2 years, but the code prescribes 10% spread over 2 years. So what is the explanation for that? You just never find it in the answering affidavit of the minister. Never. Never once does he ever explain it. So what you then have, my lady, is a paradigmatic case of irrationality. In other words, this is what irrationality looks like. It is where the facts point you in one direction, but the decision bears no connection to those facts. So that's why it's paradigmatic, really. It's a classic instance of irrationality. It's what you teach law students, that if you want to know when is a decision irrational, it is where the facts before the minister show 5%, but the decision shows 10%. Now again, I need to emphasize this. The minister could have put 20%.
Yes.
The law firms would have no right to question 20%, and the judges would have no right to question 20%. But the judges are entitled to ask the minister to rationally justify his decision. And so here he fails on the baseline of rationality. And this is not a question of the choice between 5% and 10%. Those are policy questions. So that then takes me to, again, the next glaring irregularity, which is the code. You remember that these things have not been decided by the firms. These are in the generic scorecard, and the generic scorecard contains constraints on the minister's entitlement to deviate. The next one taken up by the firms is the exclusion of the points allocation for non-lawyers. Now, there may be interesting policy reasons, but what we have to do is to confine ourselves to the reasons given at the time. What were the reasons given at the time for the non-inclusion of non-lawyers, for the exclusion of non-lawyers for purposes of management control? So we see the same pattern in 2023, August. And you will find this at 062506. And it's item 7 of that. It's dealing with management control. The explanation given here is there is no provision for non-executive directors, as only legal practitioners can be members of the board. In law firms, there are either equity directors or salaried directors. The weighting points in the case of large LSMEs are awarded only where the directors are equity, as this will ensure participation by black practitioners in ownership structures and strategic direction making within the firm, and importantly, participate in profits of the firm. Then it goes on. But that's the first document. It's based on the idea that non-lawyers are not allowed to be in management of the firms. That same reasoning appears in the updated memorandum of 2024. You will find that at 063178 under item 7, which states there is no provision for non-executive directors, as only legal practitioners can be members of the board. Similarly, in the document signed by Mr. Maputa, the same explanation is given. You will find this at 221. And in the last sentence there, it says, the targets are lower than in the generic codes due to the nature of the legal profession, in particular the fact that only admitted attorneys can be directors or partners, and the path to such directorship is not automatic, but dependent on a number of factors. Now, the question therefore is whether, as a matter of law, it is correct that non-lawyers cannot sit in boards of law firms. The law on this point is again straightforward. If an applicant like my clients can illustrate an error of law that is material to the decision, and materiality is judged by whether or not that error of law has substantially influenced the outcome, then a reviewable irregularity has been established. The case in point would be the Scalabrini case that we refer to in our bundle at page 45. It's a judgment of the Supreme Court of Appeal. Sorry, my lord, there is a portion I'm specifically looking for, which my juniors are aware of. So they say it's at paragraph 59. Oh, yes. So if you go to page 69, paragraph 59. Yes, they say this court, meaning the Supreme Court of Appeal, has said that in order to be rational, a decision must be based on accurate findings of fact and a correct application of the law. The Director General wrongly took the position that satellite offices were impermissible under the Act, and thus made an error of law. So we say that it's directly applicable here because they wrongly thought that there was an exclusion of non-lawyers from the management, when in fact there is no such exclusion in law. And so they did not get the law right. And in order to be rational, not only must they get the facts right, they must also get the law right. Yes, as my learned colleague reminds me, They conflated ownership with management. Now, one may take various views about the desirability of a policy option, whether it's good or bad. But it is irrelevant because the deviation from the generic scorecard was based on a material error of law. Then, yes, these two errors, one being a material error of fact in relation to the targets, the second being an error of law in relation to management control, are sufficient to declare the code unconstitutional, which is prayer 3 of the notice of motion. There is then a further category of exclusions. And there are 5 of those exclusions that are just wholly unexplained. Just unexplained. And even when you read the answering affidavit of the minister, they are still unexplained. Exclusion number 1 is point allocation for bursaries for black law students. Now, whether I think it's good or bad is neither here nor there. But the fact that in the previous dispensation, there was allocation for provision of bursaries by law firms, and it has been excluded, requires an explanation. And this is a point that was raised squarely in the submissions. And it has not been answered at all. The second exclusion is the exclusion of vacation programs of students who spend less than a month. You know, the recognition in the code is between 1 month to 3 months. But here's the awkwardness of the rationality. The law firms say, but students are only on holiday for less than a month, never on holiday for 3 months. And that's why the VEC work programs are designed on the basis that there will be a maximum a month. Now, you never find any engagement with that explanation by the law firms. The next exclusion is skills development spend for black employees. Somebody works in a law firm, they are a secretary, and they want to advance themselves. The law firm decides they must pay for them. They may one day be an accountant, or they may be a lawyer.
Yes.
Now, no one says that the government is obliged to do that. It's the government itself in the generic scorecard that said we would reward you if you did that. And if you want to deviate, you have to explain why. And here you find just no explanation, even for the most common and logical things. The fourth exclusion is the exclusion on socio-economic spend. Now here there is an explanation, but it illustrates an error of fact. They say we will factor this in relation to community
Pro bono.
yes, pro bono work. Yes, exactly. But the law firms point out that pro bono is too narrow.
And it's already there under
And
another act. Under the legal practice
Precise.
council.
And it's already compulsory
Yes.
under the Act. Now, this exclusion simply makes no sense. But again, it's not up to the court to decide whether it's good or bad. What is the explanation for the exclusion? Do not actually find any rational explanation for the exclusion. Then I want to deal with the last of the exclusions.
I just at this point, it is regrettable that, for instance, bursary for law students,
Yes.
no more.
Yes.
It doesn't count anymore. Skills development for employees,
Yes.
no more.
Yes.
And it's regrettable.
Yes. Well,
But as indicated, it's not for us to decide
yes.
whether it's correct or wrong, yes?
Yes, my lady. What you can say about it, my lady, which is the point we have made, is that it's retrogressive. Because it existed, it was there. It was a good thing that black students who come from low-income families could benefit from the law firms.
But no longer.
Well, they say you can do it because it's a good thing, but then, but why did they remove the incentive?
Be that as it may, yes.
Yes. There is then the final one of these exclusions. Then I have to deal with this last of the exclusions because it's become a little bit contentious, which is the exemption provision. Now, if I could, it's the exemption is somewhat complex when you try to read the code itself and try to work out.
Those are the firms that exempted from this code.
Yes, they're exempted from the code, yes. But they're exempted from the requirements that are in the code that are applicable to the 4.5%. Yes. There is a fundamental problem with it. Let me just explain. There are two problems with it. On the common cause facts, the exempted firms, which constitute 95% of the profession, on the common cause facts, 80% of those are white-only owned. White-only owned. And only 20% are either mixed or black-owned. Now, the consequence of this is that you have the 95% that simply never has to do anything under the code.
And they represent, well, almost the bulk of the legal profession.
They are the bulk of the legal profession. Now, there are some excuses given in the papers. One is that it's unfair to require ownership to change in a 3-member firm. In fact, it's no longer even about numbers now, it's about the income. The threshold is 5 million and less. It's unfair to require. The question is why? Why is it unfair?
But this is the so-called code for the legal sector,
Yes.
not for 5% of the legal
Not for the
sector.
5%, yes. And there is a further problem with this, my lady. You know, if you read the answering affidavit of the minister, when he deals with the exposition of the sector, you know, where is that? So when he deals with the exposition, the summary way he says that basically this sector is responsible for expenditure of 30 billion rands per annum. And the estimation of the top law firms is anything between, per firm, 1 billion to 4 billion. So the question then is, well, if you took that into account and you said, well, the major law firms are responsible, give or take, for anything between 4 billion and 10 billion of what is spent on the legal sector, What's happening with the 20 billion? Why should it not be subjected to economic regulation? Yes, so this you will find at paragraph 92 and 93 at page 02/1226. Yes, so 02/1225, when he says at paragraph 92, I was briefed that according to the Legal Activities and Services South Africa report in 2021, the legal sector has become increasingly competitive with an estimated value of 30 billion per annum. That's how much lawyers are making. Except
Right or wrong?
the senior counsel standing here. The sector contributes between 0.5% to 1% of the GDP in RSA. And then in paragraph 93, it is estimated that the big five law firms generate revenue of between 1 to 4 billion. So you can work on an average of 2 billion per firm, but you are still at 10 billion. But you still have a lot of money that is in the sector that has simply been excluded from economic regulation. So there are two fundamental problems with this. The first one is that if you impose a system of exemption that essentially takes out of economic regulation the system of incentives. I know they say this is not regulation, but you can regulate either by punishment or by incentive.
Yes.
And here they've regulated by incentive. So you take out the system of incentives out of them. They don't have to do anything. And the government does not have to require them to do anything. It can procure the services from all of these law firms without any of the requirements that are in the end. And where the facts show that, in fact, this is the more untransformed portion of the sector. It's the section that's been left out. It's actually where there is a need for transformation, greater than there is with the firms that we represent. Although my clients say they are in fact committed and they're working on transformation, and the statistics are there. Now, what is the rationality of the exemption? What you get when you read the answering affidavit of the Legal Services, the Legal Practice Council, is that, well, the Minister of Justice, is that in examples like taxation, it is allowed to exempt people from a certain income bracket. But this is not a tax case. It is a regulation of an economic industry by means of incentives and disincentives if you do not behave in a particular way.
Transformation.
Yes, precisely. That's what they are saying. And so what you are left with, my lady, you are left with a scenario in which the 95% with the greatest need of transformation is not subjected to economic regulation. And the question is that rationally justified on the facts that were before them? The answer to that is no, it is not rationally justified on the facts that were before them. But it also contributes to a larger point that I've tried to make in relation to the insolvency practitioner's case. When you tabulate the 4 exclusions, you add to those 4 exclusions the exempted category. What are you left with? In effect, you are left with a code that is counterproductive, a code that cannot rationally achieve the transformative objects. What you are left with a code that may introduce some disruption in the 5%, but in relation to the sector, it will leave the sector untransformed. Lady, it's already 1 o'clock. Perhaps this is the correct time for an adjournment. I still have some additional points.
Thank you. The court will adjourn until 2 o'clock.
No. I need to just explain this a little bit. Yes, I've got it now. So under PAJA, administrative action is defined to mean any decision taken or a failure to take a decision by an organ of state when exercising a power in terms of the constitution or a provincial constitution, or exercising a public power or performing a public function in terms of any legislation. We don't have to deal with a natural or juristic person because that's not where we are. And then which adversely affects the rights of any person and which has a direct external legal effect. Now, to start off with, we know that this is a decision. The promulgation of the policy or of the code is a decision. We also know that it is a decision of an administrative nature. In other words, the minister was himself not formulating policy. He was implementing it, putting it into operation. And that distinguishes it immediately from those cases where a minister is designing policy, which may or may not be binding, but here he's giving it into operation. But also, secondly, he is implementing legislation. He is implementing Section 9 and Section 11 of the Broad-Based Black Economic Empowerment Act. Then the next question is whether or not he is exercising a public power or performing a public function in terms of legislation. The answer to that is obvious. The power of promulgation is a special power conferred only upon the minister. So it's clear that it is an instance of an exercise of public power and the performance of a public function in terms of legislation. Then the next question is whether or not the decision adversely affects the rights of any person. Now, again, we know this to be true because the generic code is a benchmark against which the economic affairs of the law firms are established. It will be disrupted. The disruption may be a good thing, but it will be disrupted by the implementation of the code. So it does impact on existing vested rights and relationships. The law firms are expected, and they say severally in their founding affidavits, they say, look, we've contracted with substantial clients on the basis of our commitments to the generic scorecard and on the basis of the points that have been allocated to us under that generic scorecard.
I think that needs to be emphasized as well.
Yes.
The applicants are complying.
Yes, they are.
With the generic code.
Yeah, with the generic code,
and
yes.
I think in some instances they're 100% compliant.
And others they've
So
exceeded.
it is not a case where the firms do not want transformation. They've complied and they've spent a lot of money on complying. It is just moving on. Well, if this is the type of response we get, we will adjourn and this court proceedings will proceed virtually. Will the people who made those noise just leave the court, please? It's all of you in that section there. I have never in my life encountered, but in any event.
Yes. Melody, maybe let me just proceed. Hopefully the noise will subside.
And this is about lawyers. It's about such a proud profession. And I see a lot of lawyers sitting there, but let me not go further.
Yes. Yes, as I say, perhaps let me just proceed, and then hopefully they've heard your leadership. So the point is this: they have met their obligations under the generic scorecard.
Well, that is not in dispute.
That's not in dispute.
Notwithstanding whatever noises there are from.
Yes.
That is not in dispute on the paper.
Yes, and they've exceeded them. So the brush of resistance to transformation is a regrettable one.
Yeah.
Because the facts are that not only have they met those obligations, they've exceeded them. And it really doesn't matter what the perceptions may be, but the cold, hard facts are that those obligations in the generic scorecard have been met and exceeded. So that takes us back to the existing rights and obligations that the law firms have under the law, because they are implementing the generic scorecard. Now, those will be disrupted and they can only be disrupted lawfully. And so you go back then to the definition. There is an adverse effect if suddenly a client like Standard Bank or FNB or ABSA pulls their brief on the basis that, not on the basis that you didn't comply with the law, but on the basis that the old law has been superseded and the new law has upped or changed the requirements for compliance. That is a critical point. Now, so one cannot deny the allegation that there is an adverse effect on rights that exist and have been entrenched in terms of legislation. And then the last element is which has a direct external legal effect. Now that too is easy to establish. Under Section 10 of the Broad-Based BEE Act, these codes are binding. They are not optional. You can't, they're binding on the state. They're not optional, they're binding on the state. And when you are a law firm providing services, there is a real risk of adverse economic consequences for non-compliance. And what is not acceptable in law is for that risk to eventuate in circumstances where the code has been brought about unconstitutionally. And so that's what the case is about. This idea that there's some sort of resistance is just not borne out by any evidence whatsoever. So we would therefore submit that the code fulfills all of the elements of the definition of administrative action in PAJA. The code is not part of those elements that are excluded in the definition of administrative action under PAJA. And therefore, it is open to the court to review the substance of the code through rationality and through reasonableness. And the points I have made apply equally to rationality and reasonableness. And so we would submit, therefore, that you should apply PAJA. But as Mr. Baum said, if you are against me on that, the arguments show a total abdication of responsibility. That takes me now to remedy. If you are with us on the failure of the minister to direct his attention to considerations that are mandatory, the result is invalidity, as per the Democratic Alliance versus versus the President case. That much is clear. If you are also with us on the failure to apply the mind to the strategy, which is statutorily mandatory, the result again is invalidity because of the doctrine of ultra-vires. If you are with us on the failure of the minister to rationally justify the departures from the old generic scorecard to the new generic scorecard, the fact of the matter is that you can't strike down one element and then think that the code can survive. The striking down of that element disrupts the entire scoring, because the scoring is designed in a way that it fits like a glove. So one element that is gone means that the code cannot survive as a code. But we cannot ask this court to draft a code. So once those material elements, like sitting on the boards, like 5% as opposed to 10%, once that is struck down, the entire code falls. In other words, on the core arguments, there is no world in which one is struck down and the code survives. The code dissipates as soon as one of the critical elements goes. So we would submit.
And there's also, this court cannot insert,
No.
for instance, bursaries for black law students. The court can't insert that.
Indeed. Yes, actually, that is a great point, because the nature of it, the government says, is polycentric. So a pool on one side impacts a push on the other side because they all go together. So they have to decide, well, if the pesos are gone, are we going to replace them with what? And how are we going to reallocate the points? Yes, thank you. But the important argument to be made here is whether if you are with the applicants on point 1, the failure to take into account material circumstances, you need to examine each of the other grounds of review. This has become a somewhat complicated question in constitutional law. But there is a recent judgment, well, I don't know if 2023 is recent, but there is a judgment of Badlander AJ, Stephen Badlander AJ, which I would recommend to the court that deals with this precise point. It's called Democratic Alliance versus City of Joburg and others. Perhaps, yes.
Is it in your head?
I don't think so, my lady.
Just give us the reference.
Yes.
Oh.
Yes,
okay.
we've got the actual copies. I don't think it's yes. So there is this judgment given by Stephen Badlander AJ. If I could ask the court to go to page 17, paragraph 41, because he addresses his attention to this specific issue around the necessity to reach the other points. If you've got a crisp, decisive point on which the case can be decided, like the absence of the strategy. So he says, the question which now arises is whether it is necessary for me to reach the remaining grounds of challenge. Paragraph 42, I have given anxious consideration to this issue, particularly in the light of statements by the Constitutional Court, which might be read to suggest that I am required to do so. For example, in S versus Jordan, the court explained that where the constitutionality of a provision is challenged on a number of grounds, and the court upholds one such grounds, it is desirable that it should also express its opinion on the other challenges. Similarly, in Spilos Property Holdings versus MTN, the court criticized the SCA for having disposed of a matter on standing grounds without reaching the merits of the dispute. It emphasized that it is desirable, where possible, for a lower court to decide all issues raised in a matter before it. Then he says, it seems to me, however, that in both cases, the court was not laying down a rigid or inflexible rule, nor was it seeking to suggest that there would never be exceptional instances where it would be appropriate for a lower court to decide the matter on one ground only. It seems to me that this is such an exceptional case, having reached the conclusion that the impugned resolutions were procedurally invalid in a series of respects. It would not be appropriate for me to also deal with the substantive challenges. Instead, the more appropriate route, which pays due deference to the role of the municipal council, is to set the resolutions aside so that the council can consider these issues and all related issues properly and afresh. We would submit, particularly paragraph 44, that it's opposite in an area of policy formulation on disputed and contentious issues, that if you are satisfied that there was no proper attention given to all of the relevant considerations, and particularly that there was also no consideration given to the existence of the strategy, the question of what the new code must look like is to be referred back. We would ask that you set aside the decision of the minister, including the resultant code, and you should also order the Minister of DTIC to pay the cost of the applicants.
Thank you.
Thank you.
So, okay, Toby, I do not think there are any further questions from the bench side. You may call the solidarity matter. Mr. Becker, there's no microphone in front of you. So they need to...
Maybe swap seats.
No, that's not
Maybe
good.
swap seats.
Yes.
If you give us 5 minutes, we'll swap seats.
I'll just take this. I don't. That's going to be in 30 seconds.
I think you need to move here.
Oh, 30 seconds. Oh, there's a microphone. What's that?
It's not red. I don't know whether it's recording. I'm not sure, but maybe there's a stenographer can say that. Let's move.
Sorry? Oh, it's off. Okay.
If I may proceed, Justice.
Yes.
Justice, I see it's roughly 2:30. I would really endeavour to be finished by 4 o'clock,
You'd appreciate that.
so
and-
that the respondents have
Yeah.
the night to ponder and reflect and to prepare for what is to come tomorrow then on behalf of the respondents.
Oh, and you will also bear in mind that all the issues that were canvassed by the applicants, not necessary to repeat,
No, I
save
will
if
not.
you've got something new.
I have a number of issues, but it's hopefully not repetitive.
Thank you. May I proceed?
I would like to start my address, Justices, by referring to the comfortable fact that our hardened constitutional order doesn't permit transformation by fiat. It doesn't.
By what?
Fiat.
Yeah. Yes.
Solidarity is not opposed to transformation. No, that is peddled in all the answering affidavits, but a proper perusal thereof would reveal the contrary. As it set out in the pleadings, it acknowledges that forms of redress are imperative to correct historical wrongs, but then in a structured fashion, a reasonable, non-discriminatory, and ultimately reasonable manner.
Lawful.
Correct, my lady. That is the yardstick. Lawfulness. If I'm permitted to quote a well-known English playwright, "The king is but a man, as I am." He also said that the mean and mighty rotting together have one dust. That's what we have here. We have the legal sector as a whole being regulated now by a legal sector charter that the majority of, if not a large number of role players are saying, are not just and are not, the whole process isn't just. Now, the whole process as a starting point needs to be assessed through the prism of the constitutional democracy. Although the pursuit of equality is beyond reprieve, the attainment of equality is not unlimited, unbounded, or ultimately immune from judicial scrutiny. The current task on this court is rather simple. It's an attack on the legal sector code, and you need to pronounce whether the contents in its published form crosses all the constitutional hurdles, and whether it's legal, the principle of legality as an alternative. I'm not going to go into that argument. I think it's been extensively addressed by my two learned colleagues in the first application. All that I can say is that solidarity aligns with those principles as established also in the papers and in the written submissions. Now, as you just said, Madam Justice van Nieuwenhuizen,
Janse van Nieuwenhuizen.
Janse van Nieuwenhuizen, pardon me. I have it correct, but I expressed it wrongly. That there should ideally not be a repetition of legal argument, and I don't intend to do so. Now, to be clear, the applicant in this matter doesn't request the court to substitute its view of those of the executive on the desirability or content or objectives of transformation in our profession. It's confined to a narrow but constitutionally indispensable inquiry, namely whether the legal sector code was formatted and adopted in accordance with the empowering legislation, constitutional limits, and those that govern the exercise of public power. Now, if you read the bulk of the respondents' answers, and I must just stop at this point. The first to third respondents, i.e. the two ministers, and the Legal Practice Council are indeed those that should be before court. Now, the DTIC minister is the one that should answer. There are a lot of submissions from related parties or parties that have naturally an interest in this matter. But do we really need to focus on those submissions in addressing the core issues before this court. It will be of assistance to all the other respondents, naturally, and there's also an amicus curiae. But isn't it rather the decision of the DTIC minister that deserves to be scrutinized? And that is what I'm going to focus on, not on all the other issues that were raised. Let's look at the record, what served before the minister, and how did that inform, or maybe misinform, we wouldn't know, the ultimate decision. Now, the applicant is being accused, and as is the 4 applicants in the first matter, the 4 big legal firms, of being anti-transformation, if you look at some of the respondents as answering affidavits, that they were or are somehow acting in a fashion contra to the need to transform the legal sector. That brush is, I submit, undeserving. Let's cut through the proverbial fluff and see the wood from the trees. Let's look at the facts and leave it to this bench to apply the law. There are limited, if not any, room here for emotive and politically loaded statements. This is not the intention. It shouldn't be allowed. It's not an opportunity for colleagues to play the person, not the ball. Let's focus on the facts. Let's focus on the law and what it prescribes. Now, as argued by my learned colleagues earlier today, the Rule 53 record is the basis upon which to adjudicate the current matter. Nothing more. I have data, but can I proceed? Nothing more and nothing less, Justices. The record is the basis on which the first respondent, the DTI Minister, published or gazetted the Legal Sector Code. Now, ex post facto justification and emotive elaboration, as found in the bulk of the respondents' answering affidavits, will not change that cold, hard, empirical fact. That is what is before court. The empirical data, whether it be research or the like, should have informed the Legal Sector Code. Is unfortunately, and I'm saying unfortunately, because it is unfortunate that it's wanting. That process has costed, I don't even want to guess, but it should be millions. And if this code is now reviewed, would that go to waste? I don't know. That's an issue of remedy. But I need to refer justices in a while, when I deal with the separate points that I want to address, to erstwhile Minister Patel. He was the erstwhile Minister of the DTIC, naturally. In the affidavit that he deposed to in opposition of that application brought by those 4 interested parties, that also the bulk of them, if not all, serving on the steering committee, to have the LSC published. And that will provide an answer as to why we should not have been here today. But I'll get to that in a while.
I think you can go to your points that you want to raise. We've got your introductory remarks.
Thank you, my lady. I just want to highlight the points I want to address.
Yes.
I will not address the standard of review that I've said. Firstly, there is an unrelenting attack on Solidarity's locus standi. It's been taken by the respondents, or the bulk of them, at least the first 3. The Black Lawyers Association also took it, and a number of others. I say it's unnecessary, and I will get to that in a moment, well, it may be my personal view, but the court time is limited.
Why is Solidarity here?
My lady, because we need to be.
No, that's not. I want a legal answer.
But lady, no, I'll come. That's already the first point I'm going to address, and I'm going to address it quite substantially. I will address it. The second point is the absence of consultation, and with a specific reference to the B-BBEE Advisory Committee as established by the Act. The third point will be a brief discussion about international law. I may even forego that. It's all in the submissions, in the affidavit. The fourth brief point would be contraventions of the Employment Equity Act, also very brief. And then there would be a reference to the advocate's profession, and then the issue pertaining to the technical committee and how it's constituted. So those are not issues that would, in any event, I submit, overlap with the arguments already advanced. Let me get to locus standi, the justices. Now, the LPC and the Minister of Justice go so far as to suggest that Solidarity has no standing since it's not involved in the legal fraternity. They're not lawyers. It's not a law firm. Maybe paraphrasing, but it's the general tenor of the argument. It's further suggested that Solidarity didn't identify any particular practitioner as a member of a trade union, of the trade union Solidarity.
Can lawyers belong to a trade union?
Yes, my lady. They're employees, just like everyone else. I mean, if you're a director, you may not simply be an employee.
If you're not
but you can
working
be
for your own account, yes. Okay.
Yes, but you can be an employee. You can be a candidate attorney, you can be an associate, and you may even be a non-legal practitioner working in a firm. You may even be an academic. You may be a non-practicing attorney or advocate working for a bank or another financial institution.
No, it's just the first time in all my years in practice that I've heard about a trade. So there is a trade union for lawyers.
No, there is no. I don't know about any specific trade union. Let's call it then Sakawu, catering and allied, mostly in the catering business, for instance. Solidarity isn't confined to one industry. It's a broader trade union, much like NUMSA these days, just to use an example.
But I think following up on my sister's question,
I think
that might then be a point to investigate. Because
I would address it.
If
yes.
there's no legal trade union that Solidarity is appearing on behalf, then it does not make sense, because this is only pertaining to the legal profession.
No, my lady, respect there is no such a thing as a trade union only for lawyers that I know about.
Well, is there a trade union in the legal profession at all?
Yes, my lady.
Which one?
Like Solidarity, you have UASA. You have a number of trade unions that operate in the legal sector. They are.
Sorry, Councillor, you mentioned your HASA. What is your HASA?
United Association of South Africa. They used to be also involved in the mining industry. They're still involved. It's just an example, but I know that they have members all over. It's more general trade union, much like Solidarity. And they have different divisions, so to speak, in the trade union. Their constitution doesn't define, it's only 1, 2, 3 industries. It's the broad industry. If you're an employer and there are employees, you can be a member as an employee of whatever trade union you want to be, as long as it's not as long as it's in keeping with your constitution,
now,
which
if
it
a
is.
trade union appears, must it be mandated by its members, the specific members that have an interest in this application?
Yes, but it is like the current one. And let me then refer you to a couple of examples.
No. I want to see in the papers.
Yes, my lady.
Where's that mandate?
Let me take you there. When the legal sector code was conceptualized, Solidarity's, it was a direct translation from Afrikaans into English. They translated it as the law network or the legal network. In Afrikaans, they called the Solidariteit Rechtsgilde, legal guild, I would rather propose. They made 2 separate, substantial submissions. You would find that there's reference in the founding affidavit 01-169. That is the first submission or the second submission from Solidarity Legal Network. The first submission is referenced in footnote 2 on that page. And in that footnote 2, it said, Solidarity's Law Network submitted its initial commentary during December 2020 already. And that's not where it stops. There was a challenge in some of the answering affidavits. In the replying affidavit, it was then made clear, but you are saying we have the members, we have over 800 members in our legal network. Now the case is you can't make out a case in reply. We've dealt with that in our heads. I'm not going to repeat that, it's all there. But the Solidarity, call it the Law Guild or Law Network, its function is explained at case lines 01-171.
So it falls under the umbrella of
It's part of the trade union.
Okay.
It's part of the trade union.
Thank
It's part of Solidarity, the trade union, not the movement, the trade union.
Yes, yes.
It's a guild with a T or a D. It would be a D in this case. But 01-185, there is acknowledgement of what it does, and it's stated in Afrikaans because that was the first submission in 2020, somewhere during COVID. And I'm going to loosely translate Solidarity Legal Guild for professional legal practitioners. Paragraph 1.1 of that submission. We represent numerous attorneys, advocates, academia, legal advisors as members. That's the second point. The draft statement for consultation or leaderships would find on case lines 01-230, it's an annexure. It's the LPC's draft statement for consultation dated.
You don't need to address us any further on locus stand, I think.
Well, I had so much prepared for this point.
You can save your breath.
But just to say, but I'll get to that when I address the point of the advisory committee. I will go back to this point, but on another aspect. But it is all in the heads. It's all in the BE Act, actually. Trade unions should be there. But I'll get to that in a second. So where was I last? Yes. Point number 2. It was cut off 10 minutes of the court time. The B-BBEE Advisory Council and the composition, if any, of the technical committee. Now, your ladyships would note that Solidarity is the only party, applicant party. Well, we are the only applicant party in our own case, and there are 4 in the other case, who took this specific point. The only part to address this point is in the written submissions. And that relates to supplementary affidavit of Solidarity, paragraph 22, case lines 09-12. Now, if we look at the BEE Act, B-BBEE Act, and much is made in all the papers about this piece of legislation because it's the Enabling Act. There was reference made to Section 5. And my colleagues were kind enough to borrow me the document that was handed up with the case lines reference. It's 20-4714. The B-BBEE Act as amended, the 2013 version, I think it was amended in 2013, but be that as it may. Functions of council. So we have in paragraph 4, establishment of Black Economic Empowerment Advisory Council, and it said it's hereby established. So it is established. And what is council? It's defined in the definitions of this very act as the Black Economic Empowerment Advisory Council established by Section 4. But let's look in Section 5, functions of council. The council must, let's skip to para C. Advise on draft codes of good practice which the minister intends publishing for comment in terms of Section 9, sub 5. Section 9, sub 5, Section 9, like we know, deals with codes of good practice. And sub 5, the minister must, before issuing, replacing, or amending a code of good practice in terms of subsection 1, publish the draft code of good practice or amendment in the Gazette for public comment and grant 60 days for interested parties to comment on the draft. So, what is the council? Now, I can do no better than to refer the ladyships to the original B-BBEE Act of 2013. The unamended version, the original version. In that act, the word council is mentioned no less than 20 times. It had 15 sections, that act, of which no less than 6 are devoted to the advisory council and the deals directly with the council's powers and functions. So 6 of the original 15 sections deals with that council, and it's mentioned 20 times. This is not a discretionary issue. The council must advise on the development, amendment, or replacement, advise on the draft codes of good practice which the minister intends publishing for comment. So, what does the minister need to do? Apart from ensuring that there's a charter council, apart from all the other things he needs to do, it's called the Presidential Advisory Council. That's for a reason. Because erstwhile President Jacob Zuma appointed the council in 2014 to 2019, of which President Cyril Ramaphosa was the chairperson, of which Mr. Ibrahim Patel, the erstwhile Minister of Trade and Industry, was the vice chair. Let's look at the composition of the council. It's all there. Paragraph, section 6.
Is there a council as we...
There is. I'll take you there now, my ladies. The council consists of the president, who's the chairperson, the minister of the ministers, director general, and it goes on and on. 3 others, no less than 10 or more than 15. 2, when appointing members in terms of subsection 1B, the president shall have regard to the need for the council to have appropriate expertise, and then, here it comes. I said I should have left this point, but I'm compelled to now raise it. To represent different relevant constituencies, including trade unions, business, community-based organizations, and academics. It's a quasi or a mini NETLAC. And yes, there is a current council. There is one. There was yet another challenge to solidarity standing, and it deemed it prudent to depose to a short replying affidavit, again on that point, after a notice in terms of Rule 6.5 was received from the BLA, as well as a belated affidavit from the AFT. So if we look at case lines 23-52, right, under the solidarity case
Are you going
lines.
to address us on locus stando?
No, my lady. I'm going to address you on the legal, this advisory council and what it entails.
Yes. Just a moment.
Yes, my lady.
Yes, you may proceed.
Thank you, my lady. 23-7, Annexure RV 1. 23-7. Now that's the unsigned version. The signed version is 52, my ladies, pardon me, there are 2 versions. 23-32. Yes. That is the previous council. Sorry, my lady, I just want to get it right. The one that I've printed is now different to the one that was uploaded yesterday. 23-28, my lady. So there's President Ramaphosa, Mr. Ibrahim Patel, all the rest, Mr. Tulas Ngresi, Minister of Labour, and so it goes, trade unionists, all the, until number 20. And then there are subcommittees. The new one is 23-32. And that is the current one that now subsists.
And who's the chairperson?
No, it would be the
the
president. It would be the president. It's, by law, it should be him. But then he can appoint a minimum of 10 or a maximum of 15 others, apart from ministers, cabinet ministers, or the alternates being the DGs. So here we also have now the whole council again. Labour Movement, researchers, Black Business Council, Competition Commission, and the rest. Like Mr. James Hodge, number 12, Chief Economist of the Competition Commission. Why is this important to the composition of this council? Like I say, it's like a mini NETLAC. We know what NETLAC does now, we'll get to that just in a second. But President Ramaphosa then made a remark, a statement, 23-16, it's wrong, 23-17, where he then congratulated these new members of the council, the advisory council. And if we can turn the page, he says that they have a work to do. And part of that work is to, and I'm going to quote, it is our expectation that this council will assist us as government to enhance the implementation of B-BBEE and associated policies, such as the codes of good practice, the sector charters, and recent instruments like the DTIC's Black Industrialist Program and worker ownership requirements. So there is the council. They are being remunerated in terms of the Act. It's all there.
So where does that leave this application?
It's unlawful. The publishing of this code is unlawful. And I'll tell you why I say so, Justices. And I'm not going to speculate here. I'm going to go to the cold, hard facts and the answering affidavits. Whose answering affidavit is the one that we should focus on? The first respondents, Mr. Tau. We then challenged in paragraph 22 of the supplementary affidavit and said, we could find nowhere in the record where this was done that there was advice or a consultation with or from the Advisory Council, which has much the same type of persons as NETLAC. And we know what NETLAC is all about. Where is that? Show us. We can't see it. Now, if we look at the affidavit deposed to by Minister Patel, when he was taken on by 4 entities, or a part or most part of the steering committee to publish the code, he has set out the process that is followed. The process that is followed in order to not promulgate.
Where do we find that affidavit?
Let me give you the reference, my lady. I have.
Oh, no, it has been referred to.
Yes, but I just want to get the relevant page here. Yeah. Yeah, 082392. Yes.
Yes, thank you.
Now, onwards, my lady. Yes. So there he sets out the history, what he was given, how it came about that he did not publish the code, and why he refused to publish that code. But nowhere in that process that he described, it went to and fro the technical committee and the steering committee and all the rest, did he mention this advisory council. He didn't even mention it once.
No, it's not his decision that's before us.
The DTIC minister, he was the DTIC minister. He had to obtain the advice.
Yes, but it's not his decision that we are concerned with.
No, it's not. But I'm just saying, I'm just laying what Minister Tau has now answered. Of course, now we know Mr. Patel said nothing about that. Now we're waiting for Minister Tau to say something about that. And what does he say? He says that, well, firstly, the Minister of Justice says she doesn't know whether Mr. Tau consulted or obtained advice from the Advisory Council. The DTIC will deal with that. It's in the answering affidavit. It's also in the heads. Then Minister Tau was taken to task on that aspect, and that is case lines 15-27.
Just a moment.
Yes, my lady.
Just a moment. Yes.
Thank you.
What does the minister say about this
Paragraph
advisory council?
102 to 103 of his answering affidavit in the solidarity matter, that case lines reference of 15-27. The minister admits that the advisory council had to be consulted prior to the publication. He admits it. It's admitted. What he says is that he doesn't really know. He states that whether his predecessor, which is naturally Mr. Patel, obtained it or not, is irrelevant. He says it's irrelevant.
Paragraph? 102.
Yes, my lady, it's really there. 102 to 103, it's there. Maybe just read it. I'll just read the exact reference or the exact wording
Sorry,
there.
Council, is this on 15-27?
Yes, my lady, that is the reference I have for the for that matter. It may be unfortunate, it may be the other way around, but I'll get to that now. It's also on 082392, my lady. 082392.
Is that the
This is in the other fact.
No, this is in the solidarity one, my lady. 082392, pardon me. Because this is twice in the record, it's in both records. So,
Yes, but we want to know what the minister in this.
Yes. Yes,
This
it's
now
him.
what Mr. Tau says.
Yes. So, no, what I referred you to here, my lady, was the one for Mr. Patel. Mr. Tau is on 15-27. That is in the solidarity case line. That is Mr. Tau's affidavit.
Yes. Yes, and read the answer.
I just want to get the physical file, my lady. 1527. Yes, here it is. I have it, my lady. The contents, that's not paragraph 22, we say we can find it nowhere. Was it done? This advice. The content of this paragraph is admitted when we say they had to obtain it. Whether my predecessor obtained the advice or input from the Black Economic Empowerment Advisory Council is not relevant, quote unquote. Paragraph 23, we say, but if it wasn't done, there is an issue because it's not lawful then. The answer is paragraph 104, 15-27 case lines. The Black Economic Empowerment Advisory Council is an advisory body. Whether or not it acted in terms of Section 5 sub C doesn't render the LSC invalid. Close quote. And that is the bulk
But
of the vermins dealing with this.
Section 5 says, the council must.
Must. And the council is the advisory council, constituted of
So it's not the
21
minister must obtain advice from the council. The council must advise the minister.
yes, prior to publishing any code for comment. And why is that necessary? To prevent the steering committee in this case, and this is all in submission, from going on a frolic of their own, unsupported by empirical data or evidence, and guesstimating what this profession really needs. Why is it important to cast an objective eye over that code? Why was it called a mini NETLAC? Why is that necessary? Because we have the Competition Commission. We have trade unionists. We have academia, professors, doctors, clever people, economists, business owners saying this will lead to unbusinesslike results. This code, if promulgated or published or gazetted, would not fairly or at all address the challenges faced by this profession with transformation. It's not just. There's work to be done. And that is what
So
minister...
that's referred to people with appropriate expertise.
appropriate expertise, and I've just referred your ladyship to the annexes
Trade
to the-
unions, businesses, community-based
Yes.
organizations, and academics.
Yes, there they are, a mini NETLAC, if I may call it that. People who know. I'm a lawyer, I'm not an economist. Mr. Groenewald there is also, unfortunately, a lawyer. He's not an academia, how would he know?
Not much money to work with.
So yes, so we can talk about this for days, but some economists are going to tell you, but whatever you're going to do to these large firms or small firms or the advocates profession may not be good. Do it over or do it differently. Let's sit again, and that's what. And I need to refer you, ladyships. Now, no, it's not Mr. Patel's decision, But what he said, why he didn't publish the code in its current form, that current form. And you would find that on 08.
Just a moment. Just raise it.
So you would
Council.
find,
No, my
But-
sister's
sorry.
got something to raise.
Council, you are making reference to Mr. Patel's case, but that's not the case which is here before us today. Whilst I do accept that, Mr. Patel's affidavit does have aspects that you need to point to. Should you really be dealing with Mr. Patel's affidavit as if it was part of the matter that is here before us today?
I hear you, my lady, but the answer to that is simple. It's Mr. Tau's decision that's here.
That's the point.
But he knew about this when he came in, or he ought to have known, because this was all part of the record that his office, or part of his office, or wherever all the role players finished to this court. And all I'm saying is, you can just have regard to the conclusion of Mr. Patel, where he said, if we're going to promulgate this code in its form that you're presenting to me, there would be grave issues. And what does the steering committee and or the technical committee or whoever finalized that, what did they do? They made some minor amendment post-July
Now, whatever
2000.
they did, it was up to the decision maker to either accept that
Or not, yes. What I'm saying is, my lady, if he had due regard to the information that he should have had regard to, this code may not have been published. That's what I'm saying. So 08-2450, it's just 2 paragraphs. If the draft LSC code is gazetted unlawfully and is later reviewed and set aside, the process of transformation would be hindered and delayed. There are important stakeholders, such as large law firms that have raised objections, and associations of advocates whose objections must be addressed. That's what he says. In conclusion, in his then opposing affidavit.
wise words.
So one would, thank you, my lady, one would have expected that the new incumbent, if I may call the minister an incumbent, is appointed by the president, but the new minister in that portfolio would take heed of this, or at least be advised about this, or just take his own initiative and say, bring me the record, let me see. It was not to be. Well, it was not to be on the record. It could have been that he had regard to that. We don't know, my lady. But it's not on the record. And that is the issue. My lady, just on the point of the advisory committee, I'm nearly done. It also, if one looks at the remainder of the B-BBEE Act, there's also reference in that, as well as in, let me just get to the relevant section. Yes, statement 003.
Yes.
Deals with the development and gazetting of the sector codes. In paragraph 3 thereof. Paragraph 3.1.10 stated that the line ministry, Minister of Justice, must have been part of the drafting of the code. In addition, paragraph 3.2.5 states a committee that consists of the Sector Charter Council, Line Ministry, and Department of Trade and Industry shall analyze and consider the incorporation of public comments or inputs from members of public. And then, paragraph 6, in the same statement, paragraph 6.4.3, such a charter council, that's an establishment of the charter councils, should have information with sector members, should share information with sector members, approved accreditation agencies, B-BBEE Commission, and then the B-BBEE Presidential Advisory Council, the Line Ministry and the Minister of Trade and
That in
Industry.
statement 003.
It's there, my lady. It says you must
No, I
share
believe
this.
you. I'm just asking.
Maybe, yeah, my lady, I might have
Statement
missed a comment there.
003 and paragraph.
My lady, it's paragraph 6.4.3 of the statement.
And is it once mandatory? It must or not?
It is, my lady. It is. Let me just read it. 6.4.3. Just get there. Under the heading, role of sector charter councils, it says the main responsibilities of sector charter councils are to develop the sector codes and to monitor their implementation thereof. And then it says it may include, the 6.4, the functions of the sector may include to provide councils to share information. And then 6.5, the sector council should report, should report to the line ministry, the Minister of Trade and Industry, and the advisory council on progress made by the sector. So, at the very least, there is
So
a
not
reporting.
must, but should.
Should, mate. I'm just saying, this
But that
council
will
is so.
tie in
Yeah.
then with Section 5, because the advisory council would not know there is a code of good practice.
If they're not told.
Yes.
Yes, my lady.
So then the should advise
Yes.
will then bring it within the ambit of
Afterwards.
Section 5.
Correct. My lady, no. The section 6 or paragraph 6 is the role of the sector charter councils. It's a different thing.
Oh.
And then they should then report to the line ministry, justice, DTIC minister, and the advisory council on progress made by the sector, subject to the relevant sector codes. So I'm just saying, this advisory council is so important that it's even included under the role of the sector charter councils.
Oh,
They should
sector
also,
charter
yes.
council.
So it's not just it's irrelevant, we can ignore it. It's not that simple. It's not an irrelevant issue. It's not a guideline. This, I see, is argued by some of the respondents, is just a guideline that can be ignored at all. It's not. And that argument that's made, I'm not going to repeat it. But the compulsory issues on this advisory council have been dealt with in the B-BBEE Act, which is not something you can just ignore at all. And we have made reference, my lady, in the heads of argument. It's 18-69 on case lines. I'm not going to quote the reference. There are two pieces of relevant precedents that we've quoted there. It's paragraph 156 and 158, dealing with issues where it may be said, yes, but if you haven't followed one of the peremptory provisions, it's not necessarily a reviewable issue. But this is, if you measure it against what the Constitutional Court held numerous times in the past, this is not a trivial issue. This is not a trivial matter that you can just brush aside. Paragraph 156, and it was a quote from All Pay Consolidated Investments of the Concord. The proper approach is to establish factually whether an irregularity occurred. Then the irregularity must be legally evaluated to determine whether it amounts to a ground for review under PAJA. This legal evaluation must, where appropriate, take into account the materiality of any deviance from legal requirements by linking the question of compliance to the purpose of the provision. This is imperative to note. What is the materiality?
But it's irregularity, yes.
It's material. And what is the question of compliance with the purpose of this provision? Get an independent eye or 20 sets of eyes to look at this. But according to Minister Tau, it's in any event irrelevant. He should state then at the very least why he views it as irrelevant. Tell us it is not material. Tell the legal sector that compliance with this provision is nugatory, it's not obligatory. I can ignore it at my own peril, or at will, but this is the reason why I did it. He didn't say that. And that is an issue. Again, paragraph 158, the well-known judgment of Kirkland in the Constitutional Court. I'm going to read the last sentence. Government is not an indigent or bewildered litigant adrift on a sea of litigious uncertainty. Well, someone swallowed the Oxford Dictionary there, but to whom the courts must extend a procedure circumventing lifeline. He is the Constitution's primary agent. It must do so right. It must do right, and it must do so properly. And that is the issue at play here. It must do it right. It must do right, and it must do it properly. Now, this is only on one aspect, my ladies, that no other party raised.
Yes.
And I'm actually want to suggest that I just stop here and don't deal with all the other 5
I
issues.
think that's a good idea.
I think that's... I'm a bit too autonomous.
No, it is a new point that you've raised. And
New points are always good, my lady. Sometimes, my lady. But I will step off that. I would love to hear what the respondents have to say about
well,
that.
you will have an opportunity still in reply.
Yes, but there's nothing on paper from the other respondents, especially well, the first and second, was first and third a bit, but the rest not. So I would step off of that and just proceed to the remainder of the issues. I'll just get my notes. Yes.
You've got 2 further points.
3, my lady. But those are short points. My lady, I'm not going to entertain the whole issue of the international law. It's not really been pressed in our submissions. It's there. Don't know why. Know why it is there, but no one else really latched onto that. We raised the issue of the ILO, ICERD, and we still maintain it's relevant, but not for this. I think there are bigger issues at play. Those at most may be peripheral issues that may be justifiably raised, but that would maybe when this code, if this code passes the constitutional hurdle, then that may be an argumented a case to be argued, but I would just at this point jettison reliance on that. Then the Employment Equity Act, contravention of the PFMA. My lady, again, this is not about the principle of transformation. This is about the code being promulgated or being published, gazetted, without empirical data, without any evidence that this is actually necessary, absent evidence of properly applying the mind and the like. So what do we have here? If we then say the code in its current form, all the respondents are saying, but it doesn't transgress on the Employment Equity Act. They say it's 2 separate pieces of legislation, and you cannot refer to this one and that one. It must be in isolation. Now, let's just look at Statement 8. The very last paragraph of Statement 8 references the Employment Equity Act. It says, I think it's the Statement 8. Yes, 7, paragraph 7, it's 01-226, 7.3. The gazetting of a sector code doesn't affect any employer's obligations to comply with the Employment Equity Act and its regulations. Now, if the Employment Equity Act was so irrelevant, why is it necessary to specifically say that the gazetting of this code doesn't affect an employer's obligations in terms of the EEA? Does the employer's obligations fall away after this code is gazetted? No. You would still get your employment equity compliance documents from the Department of Employment and Labour. You would still consult and negotiate with your workforce. As a trade union, Solidarity would, for instance, sit on equity forums in workplaces where you would now say, let's look at the generic codes. Let's look at what we plan for this employer. Employer, tell us. Black women, black males, middle management as an example. We're sitting, we have a head count of 100, we only have 15. We want to go to 30. Labour says it's fine, unrepresented, maybe have a workplace forum, they say it's fine. They then draw up their minute, the Employment Equity Forum minute, they sign it off, they submit it to the to the Department of Labour and Employment and Labour, and they say, please, here is our report, look at it. If you're happy, it will be valid for the next number of years. We have 50 or more employees, so we're compelled to comply. We can even comply voluntarily, but in this instance, we have 100 employees, and so the turnover is not applicable, or actually relevant because you have more than the threshold. So now you say, we have a 2.5% target. On middle management, top management, we have a 3.5% target. Not a quota, but that's unlawful. A target. Enters the legal sector code. Here is your target. Employer says, I'm a corporate firm. We have 300 employees, but we only have 100 lawyers. What shall I do with the other 200? Now, don't worry, you must comply with the legal sector code. Then the employer would say, but they say we don't count those individuals. Say, no, but don't worry, you must still comply with the Employment Equity Act, with your own Employment Equity Act plan. How would that work in practice? So, whoever drafted this code now decides for an employer who needs to comply with the EEA, these are your targets. They also decide that you comply. But now, you have an attorney firm, a rural attorney firm, 10 employees, turnover of 8 million rand a year. They must comply. Only 10 employees. Well, they have a turnover of 5.1 million rand a year. Just an example. In terms of the EEA, they don't have to comply. In terms of the LSC, they must comply.
Well, there are different reasons
Yes,
for
yes,
the
there
legal
definitely
sector
might
code to apply.
Yes, yes, but the problem comes in, if you are compelled to comply, 50 plus 1 employees, for instance, it creates a situation where there are targets now being imposed on employers without consultation, and consultation is key.
So the one
Consensus
left
seeking.
hand does not know what their right hand is
Correct,
doing.
my lady. So what must I now say as an owner of a large law firm or a director, if the Department of Employment Labour comes and says, well, what are you doing? You said you're going to go to X%, now you're on Y. You're outside the scope of your own plan. It's just an example. So that is an issue. So actually, some employers are penalized for non-compliance, and then other employers have literally no incentive to even drive some form of transformation at the very least. And I think those examples were given by my colleagues earlier. Now, I must state this. It may not be, well, it's factual. The Employment Equity Act says it's discrimination to pay individuals differently. Equal work for equal pay or work of equal value. So if I'm a candidate attorney at a firm and I earn 10,000 Rand a month in month 1, and my colleague earns 10,000 Rand a month in month 1, I have no reason to complain. If my colleague is in month 1, same qualification, and he earns 15 and I earn 10, what is the basis for that? That is discrimination because it's equal work for equal pay or work of equal value. That's a tried principle been established.
Why is this relevant in this
Because, my lady, the sector code gives you, just as an example, and I'm just making this one point to say it's not rational, 01-59 on Solidarity's papers. You receive bonus points when you incur expenditure as a result of a top-up monthly remuneration of black CLPs. So you get bonus points if you pay what they call black CLPs, a top-up monthly remuneration. So you will have a white lady, also fresh out of university, saying, but why do I get 10 and you get 15? So, well, go and ask the legal sector code.
But this matter is not about equal pay for equal work.
No, my lady, it's not. But I'm just saying it is irrational because it establishes principles, it seeks to establish that may result in an issue where the EEA is breached, where you pay a top-up.
But is that an issue in this legal sector code?
Yes, my lady, it's there.
Result in unequal payment for equal work.
Well,
I
if you
haven't-
follow this, it will, my
I
lady.
haven't read it in the paper.
Yeah, no, it's just that one aspect. I'm just highlighting that. I'm not saying it in totality.
All I'm just saying
Yes.
is distracting from the issue in this matter. That's why I'm
Yes.
querying.
No, my lady, I'm just mentioning it to say that this thing wasn't thought through because it may even result in a breach of other legislation
I think
like
we've
employment
got that
equity.
point. Thank
Yes.
you.
That will then move on, my lady. Then we come to the issue of the advocates who it's been touched on, but not really. We know that Minister Taus expressly said that the issues with regards to the advocates have not been particularly addressed or at all. We know there were objections or comments from KZN Bar, Cape Bar, Pretoria Bar, as well as the Johannesburg Bar, which I could pick up. Of all of them, all I could pick up was a cursory answer to some of the issues raised by the KZN Bar. And that is one that affidavit of Mr. Tau says, but you haven't addressed at least the JSA, to some extent, Pretoria Bar and Cape Bar. So those have not been really addressed. And I submit it's still not addressed. And I'm saying so for the following reasons. We have stated in our written submission, I'm going to repeat that, the right to choose one's legal representative, etc., free economic activity, right to participate in occupation of your choice, and the rest. But coming to the advocate's profession, of all those goals and all those issues raised, only one was made applicable, and that's the one of skills development. So we have the advocate's profession, who is only measured on skills development. Whereas the attorneys, if they have a threshold of 5 billion and under turnover, they're exempted. But the advocates have a threshold of 3 million. Why? It's been asked. It's never been answered. It's been asked numerous times in all those submissions. Why? Where do you base that threshold on? Why advocates 3 million and attorneys 5 million? There's simply no answer. The answer was, there was an answer. It was said that the members of the steering committee have lived experience or have experience or knowledge of this aspect. No empirical data. Yes, it's easy to know after the fact, say. Let's look at, for instance, the data from membership, whatever you want to call it, from Joburg Society or Pretoria Society, whatever society. At the point in time, in 2024, that wasn't before the minister or the drafters of the code, nor was elaborated on in any records. Now, how would you, if there are any barriers identified, how would you eradicate that? Investigate it properly. It wasn't done. If we then, I'm not going to read the Pretoria Bar's criticisms, nor the KZN Bar, it's all in the record, but I can assure you, ladyships, all of these issues were pertinently raised. To say, well, how do you get to this? Tell us. And they say, all of them made submissions that they're concerned that this may prevent entrance into the advocate's profession. It will, in its current form, lead to that, because now you have a turnover of less than 3 million, for instance, then you're exempted. Now you go over, now you must do training for a set amount of hours per year. You must actually contribute, if you can't do the training, to a skills transformation fund. Some advocates wouldn't be able to afford it, but it's only white advocates that need to contribute if they can't do the training, because they should train, and it says black advocates and black women advocates. So that is what it says.
We're starting now on merits and policy decisions.
No, I'm just saying, that is what, no one touched on this, and that is what was said by the bars in its submissions. It wasn't dealt with by the minister. That's the issue.
The issue is whether or not the minister applies his mind.
Yes, did he look at that?
Whether or not it's a good or a bad policy.
No, my lady.
That is not the issue.
Yes, my lady.
And I get the impression from the submission that we are now venturing into that territory.
No, my lady, that's not the intention.
So
I must make it clear.
The only issue is whether or not the minister applied his mind to what was placed before him.
I just wanted,
and
yes.
that was exhaustively addressed by the first and the second.
Yes, madam. I'm just saying that point was not addressed by any other applicant or respondent in this matter.
The first point you raised was not.
So, my lady, I'm just saying that was all before the minister, and there's no evidence that he actually applied his mind to that. And now the advocates sit in a situation where, according to the submissions and the information at the time, where they don't know how they came to such a conclusion, and that is the issue. Nothing more than that.
Are you
Now,
still going to address this on a technical committee?
my lady, there's just one other issue I would want to address. Mr. Toby also then in his heads addressed an example of the absurd results that may follow if this is not properly addressed by this court. I'm not going to read it into the record. It's paragraph 146 to 148 of his heads. We've also made the same examples that would lead to unbusinesslike or absurd results. Also, glass ceiling type of thing, and how do we get to the percentages and all the rest. That's not that me. Okay, good. Then the last point, my lady. The steering committee and the technical committee. The minister refers to the technical committee over and over again, yet there's absolutely no indication in the code or in the B-BBEE Act that there is even such a thing catered for as a technical committee. It may be something that the minister thought out, or the steering committee, but we've made the point in our heads that the members of the technical committee were the same as the members of the steering committee. Okay. They were the same people. Where's the objectivity? So here we have the steering committee from the LPC. They say they didn't draft it, they didn't author it. The examples in the heads which we've quoted, it say we have done this and this is LPC. But good, let's give them benefit of the doubt. There's the steering committee. So we have now a green hat. We have the steering committee. We draft this. Take it to the minister. He's got questions. We put on a red hat. We're now the technical committee.
But wasn't there also officials from the department?
No, there were 1 or 2 officials from the department. It's correct. But I'm just saying that the general composition of the technical committee is much the same. The steering committee's members also serve there. So that is an issue, and also we've raised the point.
It is an issue. Why? Because the minister at the end of the day had to apply his mind.
My lady, but that, now I'm coming back to the point of the advisory council. That's why it's so important to have an advisory council.
Yes,
and
no,
that
that
is
point
the point.
we've taken.
Yes, that's the point. So here we have these allegations, they may not be a bit biased, wouldn't exist if there was an advisory council. Well, we've run it past the president and all the ones that he's appointed. So don't complain, we've done what we were supposed to do, but it's nowhere in the record. And then the issue of remedy money. You can't read in, you can't sever. I must submit an argument that in its current state, it would be a mess to do that. You cannot do that. It's just purely unlawful. On the issue of cost, it should be set aside in totality. There are generic codes that can be used in the meantime. It's there at least. Yes. There is a fallback position. It's not that there's a lacuna. On the issue of costs, we would now hear tomorrow and the day thereafter who still takes the point of locus standi. Those who persist with that, lady, we will see costs against. Those who then jettison that, don't think it will be an issue. Don't think I'll get an instruction to pursue costs. But in general, the buy-watch principle and the remainder of the issue, the main application, I'm not going to preach to the converted. We know what the buy-watch principle states. Should we not succeed, there should be no cost. It's a constitutional challenge. Should there be success in this matter, solidarity, at least against the first 3 respondents, should be able to then recoup their costs of 2 council, not 4 or 5.
Well, shouldn't it be the first respondent?
Yes, but I'm saying we're not going to burden the rest of the respondents. I mean, they're part of the legal fraternity. Although all of them ask for solidarity's application to be dismissed with costs, we're not going to do the same. They're not that heartless. We're doing this for the greater good and for clarity in this profession, yes. Not about costs orders. So yes, unless there's anything else, my ladies, I think we have 25 minutes left of the day. I can still talk another 25 minutes.
No, it's important. Thank you. No, it's been very valuable. Thank you so much, Mr. Becker.
All pleases, my ladies.
Thank you. We've got 25 minutes, Mr. Nalani. Mr. Arendse? Yes.
I'm just rising I appear for the General Counsel of the Bar, and what I intend to say, I don't have instructions. It's to raise a matter of concern I think you remarked on the collective groan, but also amongst the respondents' council, there's a lot of concern about your ladyship's remarks that the applicants, to the effect that the applicants are compliant and that this code will make them non-compliant. There is a concern that such remarks may or does manifest some bias on the part of your ladyship presiding.
Is it
They are
factually
going to-
Is it factually correct or not?
Your remarks, my lady.
No, where I got this information is from the affidavits. So it is not something that I sought out myself. When I read through all the documents, and we'll still hear, you know what it's like. If you hear the respondents, you may change your view. What I said about the generic code, that as far as I understood the papers, so what I've read, is that the applicants' firms comply with the generic code. That is what I said. So what is the problem?
Well, I speak subject to correction, my lady, if it's not borne out by the
Just a
the
moment.
transcript, but that's what we heard.
Yes, you may proceed.
My lady, all I'm just getting up to say is that overnight the respondents will take up this matter with their clients and discuss it, and we'll revert in the morning, my lady.
100%. It's always, as procedures go, it's absolute your clients and the other respondents, absolute, they're right in law.
If,
I do not know what my...
I didn't get the impression that your ladyship was reading or quoting from the papers or from any part of an affidavit. That didn't. But I may have heard it wrongly or picked it up wrongly.
Do you want us to go to the founding affidavit? Have you read the founding affidavit, Mr. Orange?
I think so, my lady.
So,
I wouldn't be here if I didn't.
We can go to it now, and in the founding affidavit of the first applicant, it is stated that they are 100% compliant.
I know that
So-
those submissions to that effect was made by my colleague.
It
Mr.
is not
Nguke told me.
under oath
He
in-
made that, but I'm talking about the comments your ladyship made from the bench.
That the first applicant or the applicants are 100% compliant with the generic code.
That's a submission that they made. I know, I understand that that's in the...
No. We've got some time. Let's go to the founding papers.
My lady,
Find the founding affidavit of the first respondent, because you know very well, you're very senior, if you want to make these type of submissions in open court, it must be factually based. Just a moment. Kan jy dit vandag nie founding kry?
My lady, I do recall that's what they say in their papers. That's why
I
they
beg your
say
pardon?
that... I do recall that is what they contend, and that's the submissions they made. I'm not referring to
Stated
that part.
under oath, Mr. Orange. If there was a dispute, then I would, in the normal Plascon evidence, normal legal procedure, that is specifically denied, and the reasons are given. So what I've placed, what I've put to council, is what is in affidavit and the oath, and dispute. But you may take your instructions.
My lady, all I've been asked by some, not all, some of my colleagues that we conferred with on WhatsApp was to place this on record and that we will take the matter under advisement
Do you want
after
to bring
the
an
adjournment.
application for my recusal?
Well, I don't know, my lady.
Because
if-
then we need to prepare. We've got so much time. You must tell us, because we must prepare for a type of a judgment. Otherwise, we're going to waste 3 more days.
Yes.
But I mean, I would just appreciate if those are your instructions, that your time is let the bench know. Because we are going to prepare further to come here tomorrow to listen to the respondents. And if you want to bring an application for my recusal, kindly let us know. Because then we need to prepare on something else.
So perhaps, my lady, it would perhaps be opportune to take a short
I
adjournment
think so.
for
So that we know what
Respondent
we
Council to confer, and I'll
I would appreciate it, Mr. Orange, because then we know what to concentrate on for our preparation for tomorrow. Court will
Thank you.
adjourn.